Good evening. Hello, and welcome tonight. If people can go ahead and take their seats, we'd like to go ahead and get started. Welcome to the City of Santa Monica City Attorney's Office, Rent Control Board, and tonight Code Enforcement 2025 Landlord-Tenant Forum. My name's Romy Ganshaw. I'm the Chief Deputy City Attorney for the Consumer Protection Unit in the City Attorney's Office. I'm joined here tonight with all the colleagues of my unit and staff from Rent Control and Code Enforcement who will introduce themselves when they come up. And we have actually quite a long agenda tonight, so we want to go ahead and get started. And we hope to have some time for questions at the end. So we will ask that you hold your questions till the end so we can do that. Oops. So just to give an overview of what we're going to discuss tonight, we're going to hear a presentation from Rent Control regarding a new regulation related to maximum rent increases at any given time, as well as limits on price gouging that apply to rent control and non-rent controlled properties. We're also going to hear about the expansion of the POD program. We'll also have then a presentation from Code Enforcement regarding the new vacant property registration code that was adopted by the City Council actually last night. And then separately, a new rental housing registration ordinance that was adopted by the City Council a couple of weeks ago that applies to non-rent controlled units. Then we'll have a discussion of some new statewide landlord-tenant laws, in addition to those local laws that take effect next year, and a discussion of an existing Santa Monica housing law, which is the residential leasing requirements law. That's been in effect for a while, but thought it'd be helpful to do a little bit of a brush up. And then finally, we'll do a review of some highlights of tenant harassment, relocation, and fair housing cases that the City Attorney's Office has been litigating over the past year. And again, hopefully we'll have some time for questions. So go ahead and get started with Rose from Rent Control.
Thank you. Good evening. Thank you for coming. So my name is Rose Patel, and I'm a public information analyst at the Rent Control Board. To begin tonight's presentation, I'd like to walk you through the recent changes to a key rent control regulation, specifically the rule that governs how landlords apply their banked rent increases. So, before we get into the actual changes of the regulation, I'd like to briefly review how the general adjustment, which is the rent increases, worked under the previous rule. So, as you may know, the general adjustments are applied once a year, September 1st of every year. You have a new increase, rent increase that comes into play, and it's for all eligible units in rent control. And the GA is also not any more than 3%. It depends every year. It's different. It's depending on the inflation rate, but it's never more than 3%. That's based on the regulation. And any increase requires, as per state law, that the landlord gives a written notice to the tenants. That is a requirement of state law. And the thing is that not every landlord chooses to take those increases every year. Some landlords do. They follow what we send them, information that our office sends them in terms of how much they can increase the rent every year. And some landlords don't, by choice. And when they don't, at some point, they are able to take those increases. That's what we call the bank increases. They can go take 3 or 4, 5, 6, 10 years all at once. And that does mean sometimes that you're going to get increases that are over the 10% limit, and it could be several in 1 year. With the new changes, basically, in order to protect tenants from large increases, like what I just described, that could be over 10%, like 10 years worth of increase in one time or 2 times. In order to protect from that, the regulation was changed. The landlords may still take the rent raises up to the MAR, but how they do that is now limited. So the new change is basically going to limit them to a 10% increase in a 12-month period. So 1 year, one increase of 10%. They can't do several 10% in 1 year. And this is going to take effect, took effect October 15th. So anything after that date, if you're getting a rent increase that's over 10%, then we can address that. We have petition processes that we can do, such as excess rent petition that can address any kind of increase that's over 10%. For anything like that, like over 10% increases that you may have received before October 15th, those would be addressed by the price gouging ordinance. That was put in place for the fires. The anti-price gouging laws that is handled by the city attorney's office, and they will address this right after this presentation about this increase. And basically, the change that we made, as you can see on the slide here, it's also to align with state and local ordinance. The local ordinance is the price gouging that I mentioned, and the state law that was put in place in 2019 that does limit increases to not exceed 10%. So that puts rent control regulations in line with that, with those laws. So if for any increase, like I said, that occurred before October 15th, if it was over 10%, price gouging laws will address that, and my colleague from the city attorney's office is gonna talk more about the price gouging. Andrew?
Good evening, everybody. So I'm from the City Attorney's Office, and I'm going to be talking about price gouging in rental housing. So as we know, we've had a state of emergency from the fires. There have been other states of emergencies from COVID and otherwise. And in those states of emergency, sometimes price gouging laws are triggered. So I want to walk through how those work. So I'm going to do a quick overview of our presentation here. First, we're going to talk about what is price gouging. Then we're going to talk about what is price gouging in rental housing. Then we'll discuss what is the rent limit for price gouging. And finally, the consequences for price gouging. So let's start with part one. What is price gouging? Price gouging is a crime. So if we want to know what it is, we have to look at the penal code. This is the penal code. Let's open it up. This is what it looks like. This is Penal Code 396. As you can see, it's actually quite long. Of course, it's also available online. If you're modern and technological, you can find this online very easily. But if you're like me, I like to open up the book and actually read it. We're not going to go through all of it, because as you can see, it's actually quite long. This is Penal Code 396, the price gouging law, but we're going to talk about a few key parts. Let's take a closer look. Even then, you don't see very much. But here are the 4 parts we're going to talk about. And I'm going to go through it, so don't worry. I know it can't be seen on the screen. First, we're going to talk about what is price gouging. That's the part that's highlighted there. That's the little circle saying it talks about what price gouging is. Then we're going to talk about how it applies to rent. That's that highlighted portion there. Then we're going to talk about what it actually means in terms of the rent cap. And then finally, the consequences for it, which are highlighted right there. So let's go through each of these one by one. We'll start off with, what is Penal Code 396? As I mentioned, this is the price gouging law in California, and it prohibits price gouging for certain goods and services upon the declaration of a state of emergency. Why did the legislature pass a law for price gouging? Well, the law tells us. It's right there in the law. And what the law says is that it's the intent of the legislature to protect citizens from excessive and unjustified increases in the prices charged during or shortly after a declared state of emergency or local emergency for goods and services that are vital and necessary for the health, safety, and welfare of consumers. So this only applies to certain goods and services that are, according to the legislature, deemed necessary for health, safety, and welfare of consumers. Housing is, of course, necessary for the health, safety, and welfare of consumers, so it's included in this law. Also, I just want to note that the governor may issue executive orders regarding price gouging, including orders that may modify parts of Penal Code 396, so that's something to keep an eye out. They're all posted on the governor's website. They're called executive orders. Keep an eye out for those during times of emergency in case there's some modification that the governor issues an order for regarding Penal Code 396. Okay, also please note, the goal of this presentation is to provide an overview of certain parts of Penal Code 396. As you saw from the highlights, I'm not going to talk about everything, and I'm not going to cover all applications and all exceptions, but I hope to give you a good overview of how it applies to rental housing. So let's get there. What is price gouging in rental housing? Well, there's a subsection, Penal Code 396E, which explains what it is, and it says that it applies when the president or the governor proclaims a state of emergency, or when a city or county declares a local emergency for 30 days after and as extended by the applicable authority. And as we know in our current state of emergency regarding the Palisades fire, those may be extended repeatedly by the appropriate authority. So the governor proclaimed a state of emergency with respect to the Palisades fire on January 7th, 2025, and the County of Los Angeles extended those price gouging protections through January 28th, 2026. They did that at their most recent board meeting, and they may extend it further. So what does this subsection actually do? What's the rule under Penal Code 396E? Well, the rule is that during a state of emergency, it is unlawful to increase the rental price, and I'm going to slow down here, advertised, offered, or charged for housing to an existing or prospective tenant by more than 10%. And the reason I slowed down there is because each one of those words is really important. So it's unlawful during a state of emergency to increase the rental price. We'll talk about what that means exactly. Advertised. So that means if it's an advertisement on Zillow or if it's an advertisement on Craigslist or anywhere else, that is covered by this law. Offered. So if it's actually offered to a prospective tenant, that could be in writing or orally or otherwise, or actually charged. So the actual amount that was charged for housing. And you'll notice also this applies both to existing and prospective tenants, so make sure to apply it both to your existing and prospective tenants by more than 10%. We'll get into the details of all this. I do want to note there's this exception that a greater rental price increase is not unlawful if it's directly attributable to additional costs for repairs, but those additional costs of repairs have to be beyond normal maintenance that was amortized over the rental term, or if it was already agreed upon between the parties. So that is an important exception in case it applies. Now, to get to the most interesting question, what is the rent limit for price gouging? Well, as you saw, and as we already discussed, it's 10%. There it is. But how does that 10% actually apply? Well, it depends on the situation. We're going to go through all the situations covered by the law here. Rental price is defined in the definition section of Penal Code 396. Here, 396J11 defines rental price, and it defines it for different situations. So I call this the base rent, just as a way to understand that you can charge 10% above the base rent. But what is the base rent? Well, let's look at situation number one. This is sort of the simplest situation. For housing rented within 1 year prior to the time of the emergency, the rental price means the actual rent paid by the tenant. And so that's the base rent. So then you can charge 10% above that. Well, how would this work? Well, let's say a tenant moves in, and then that's a siren symbol to indicate an emergency occurs. The governor perhaps declares a state of emergency, or the local authority does. The tenant is renting during that emergency. The emergency keeps going, and then the landlord raises the rent by the allowable amount, which would be 10% above the rental price actually paid by the tenant when they were living there during that emergency. So this is sort of the simple scenario. You have a tenant living there. There's a declared state of emergency by the governor, and then you can charge 10% above that at the appropriate time. But, what if the housing is rented at the time of the emergency, but then it becomes vacant during the emergency, and it's subject to local rent control? What then is the base rent that a landlord can charge 10% more of? Well, it gets a little complicated here because the law says that the rent then is the rent paid by the previous tenant or 160% of the fair market rent, whichever is greater. And you'll notice there's a little asterisk there because this is a situation where the law allows in this case, the Los Angeles County Board of Supervisors to adjust that number, and they did so up to 200% to reflect local housing market conditions. So what does this look like? Well, let's go through a timeline again. A tenant moves in. There's a declared state of emergency. The tenant is renting during that emergency as prior. The emergency continues. The tenant moves out. It's now vacant. Emergency is still going on. and then a new tenant moves in. At that point, the landlord can charge 10% more than either the rent paid by that previous tenant who was renting during the emergency, or in this case, at this time, 200% of fair market rent as authorized by the Los Angeles County Board of Supervisors. So that's what a landlord could charge that new tenant. Next situation covered by the law is this. For housing not rented at the time of the emergency, but rented or offered for rent within 1 year prior, the rental price here means that it's the most recent rental price offered before the emergency. So let's take out our little icons again here. So the previous tenant moved out, the unit is vacant. Declared state of emergency occurs, the unit's still vacant, the emergency keeps going, a new tenant moves in, So that means here, the landlord could charge that new tenant 10% above what the most recent rental price was before the emergency. We got 2 more situations to go through here. Situation number 4. For housing that was not rented and not offered for rent within 1 year prior to the emergency, the rental price means 160% of fair market rent. Again, at the current time for the state of emergency, it's been raised to 200% of fair market rent. So let's see what that might look like in practice. So you have a unit here that was not rented or offered for rent within 1 year prior to the emergency. Then the emergency occurs, and you can see that big time gap there to indicate that. The unit is vacant, the emergency is ongoing, and then a tenant moves in. At that point, the landlord could charge 200% of fair market, 10% above 200% of fair market rent. And situation number 5, this is our final one. For housing where a tenant was evicted during the emergency, a landlord cannot rent or offer to rent to another person at a rental price greater than the evicted tenant could have been charged. So again, tenant moves in, state of emergency is declared, tenant's renting during that emergency as an example, tenant is evicted, emergency is ongoing, new tenant moves in. In that case, the landlord could not charge a rental price greater than the evicted tenant could have been charged, and we can look back to the previous scenarios to see how that would apply. So that's kind of the outline of how this works. There is an additional consideration, which is the law provides for an additional 5% increase if the unit is fully furnished. And you can see how that applies here. For those first few situations, the amount may be increased by 5% if the housing was previously rented or offered for rent unfurnished and is now being offered for rent fully furnished. And then for those situations where the housing was not rented and not offered for rent within 1 year prior to the emergency, there the amount may be increased by 5% if offered fully furnished. So that's how the law works. And now let's go to that final portion that I highlighted earlier, which are the consequences. So what are the consequences of violating Penal Code 396? Well, it is a criminal law, as we discussed before, and a violation of that penal code is a misdemeanor. Reports of alleged violations may be sent to the California Department of Justice, the Los Angeles County District Attorney's Office, or the Santa Monica City Attorney's Office. All of these offices prosecute this crime, as you can see there. In addition, a violation of Penal Code 396 also constitutes unfair competition under the unfair competition law, which a number of offices and district attorney's offices also enforce. That's Business and Professions Code 17200. So in closing for this, that's it. We can close the book. So there's one other topic that I want to address about prices in rentals, and that's permanent relocation. So the city has a permanent relocation ordinance, and it's been codified under Santa Monica Municipal Code section 4.36.020. And I want to talk about one of those subsections where permanent relocation is required. So for this section 2, I'll give you a quick overview. Part 1 is going to be when is a permanent relocation fee due under SMMC Santa Monica Municipal Code section 4.36.020A5. A5 is going to be the topic of discussion today. Then we'll talk about how much is the permanent relocation fee. We'll discuss how is it to be paid. And then we'll run through a frequently asked question. Just one question. That's why there's no S there. One frequently asked question. So when is a permanent relocation fee required? You can't really read that, but I'll read it to you. It says when permanent relocation fee required. And then it says essentially a permanent relocation fee is required when. And then there's these 8 possible scenarios where it's required. And I'm only going to talk about the 5th one, but they're all important and deserve attention. But for this one, we're going to focus on the 5th. And there it is. A landlord shall pay a relocation fee to a tenant whose tenancy is terminated or caused to be terminated in any of the following circumstances. And this is the circumstance we're going to look at today. I'll read it for the sake of saying it all at once, but then I'll break it down. The tenant elects to relinquish their tenancy within 120 days after service of notice of rent increase that exceeds the lesser of 1, the consumer price index, all urban consumers, plus 5%, or 2, 10%. For purposes of this subsection, the proposed rental increase, whether imposed as a single increase or payable periodically over a 12-month period, shall be calculated based on the highest legal monthly rate of rent established as of the date of the notice of rent increase, not any temporary promotional or discounted rent. So let's break that down. Part 1. When is this thing due under 4.36.020A5? A landlord must pay a relocation fee if 2 things apply. 1, the landlord serves a notice of rent increase that is higher than CPI, Consumer Price Index, plus 5%, or higher than 10%, because it'll be whichever one's higher. And, factor 2, the tenant relinquishes their tenancy within 120 days after the landlord serves the notice of rent increase. Note, the base rent here is the highest monthly rent as of the date of the notice of rent increase. It's important to note, too, that it does not include any temporary promotional or discounted rates because it's intended to capture the actual rent. So that's when it applies. How much is the fee? Well, the fee can be found online here, and it's adjusted annually. This is the current fee schedule, and you'll notice that it depends on the housing type, and then there's you see the relocation fee there, and then an additional fee if there's a household that includes senior, disabled, or minors. And as I mentioned, this is updated annually on July 1st, so you can always find it on our website. And then how is the permanent relocation fee paid? Well, this is true for all permanent relocation fees, including this one. A landlord must place the relocation fee in an escrow account within 2 working days of notice by the tenant that the tenant will relinquish the tenancy. It's also possible to place it into another account approved by the city, but the default is an escrow account. Then, within 2 working days of a written request by the tenant, the landlord must instruct the escrow holder to pay part or all of the relocation fee for moving expenses or replacement housing within 3 working days. The idea there is that the money becomes available for the tenant to use for moving expenses at the time where it would be necessary to use it for moving expenses. And then within 2 working days of when the tenant actually vacates and moves out of the unit, the landlord must then instruct the escrow holder to pay the relocation fee within 3 working days after that. So that'd be a total of 5 working days after the tenant moves out. There's the citation for how that works. And then finally, our frequently asked question. What if the landlord notices a rent increase above the threshold amount, and then the tenant goes ahead and says, I want to relinquish my tenancy, and they do that within 120 days, but then the landlord later withdraws the rent increase? What happens then? Well, I just described the situation, but here's an example. Landlord serves a notice of rent increase of 11% on January 1st. The tenant elects to relinquish their tenancy on February 1st with a move-out date of March 1st. On February 15th, the landlord reconsiders and decides to withdraw the notice of rent increase. Then the tenant moves out as planned on March 1st. Here's the question. Does the landlord still have to pay the tenant the relocation fee? Yes, they do. Why? Because it met those 2 conditions that triggers the relocation fee payment. First, the landlord served that notice of rent increase that's higher than CPI plus 5% or higher than 10%. And second, the tenant relinquished their tenancy within 120 days after the landlord serves the notice of rent increase. So this is an important one of the possible scenarios where a relocation fee would be required. It's important for landlords and tenants to both know about this so that they can both enjoy their rights and have them respected. I appreciate your time. I'm going to pass it on now to Dan Costello from Rent Control to talk about our next topic. Okay, thanks.
Was that applause for him or for me? So my name is Dan Costello. I'm the Public Information Manager for Rent Control, and I just want to have a couple of slides to introduce, maybe not introduce, but highlight 2 financial assistance programs that are relevant to tenants and landlords. And neither of these are rent control programs, but we really want to make sure that everybody's aware of these because they could really help somebody out. So the first of it is the POD program, that's Preserving Our Diversity. And I'd like to introduce that just by telling a story of a good friend of mine who is a long-term renter in Santa Monica and raised his son here. And he's a art director and worked on many big movies like Men in Black and Spider-Man and Mulan, the live action one, going all the way back to Fargo. So he had a successful career, but as many of you know, there haven't been a lot of productions in the Los Angeles area recently. So my friend was out of work for 3 years. He had no income. And it was getting to the point where he was about to lose his rent-controlled apartment. So I told him about this program, and he applied, and now he's receiving the assistance. So it can be a real lifesaver for some people. So, you know, many long-term Santa Monica renters, especially those living on a fixed income, are at risk of being displaced because they can't afford the basics of food, rent, utilities, medical care, transportation, and all the other expenses of life. And to help these people, the city's Housing and Human Services Division has a program, POD, and we really wanted to try to keep these people in our community by providing monthly cash assistance in the form of a debit card that's funded monthly. So the requirements are that the tenant has to be at least 65 years of age. They must be living in a rent-controlled unit since before January 1st of 2010. So this is the expansion part of this program. When it was first introduced, tenants had to be in place prior to the year 2000. So this adds many, many more units where tenants might qualify. The tenant does have to be low income, and for a one-person household, that's $53,000, and for a two-person, it's $60,600. There's a schedule going up to 4 people or more. So whoever is applying for this can check to see if they might qualify. But it's not available to tenants who are already participating in an affordable housing program, such as Section 8 or one of the city's affordable housing units. It's only for those not participating in that. And if a tenant qualifies, it provides a minimum monthly after rent income of $986 for a one-person household or $1,724 for a two-person household. The application is there on the screen, but I don't know if anyone in this room would qualify. But if you think that you would, I would certainly encourage you to apply. And more importantly, or just as importantly, if you know anybody who you think might qualify for this program, I really encourage you to let them know about it and encourage them to apply. The applications are put into a lottery, and then qualifying tenants are chosen from that list. So getting on the list is a key thing. So the next is the LA County Emergency Rent Relief Program, which I frankly only learned about today. But that is a program of the LA County Department of Consumer and Business Affairs, and it provides financial assistance to qualifying property owners who have been impacted by the recent emergencies. And that includes both the fires from earlier this year, as well as other emergencies. It doesn't really specify. But landlords can apply for up to 6 months of outstanding rent that they've not been paid, and that's up to $15,000 per unit. The funds can be used for rent, mortgage, other expenses, as long as it's directly related to the financial hardship caused by an emergency. There are priorities for the program. The county is focusing on areas that are defined as the highest need or high need economic areas, still using some maps that were developed during COVID to identify those areas. I don't know if Santa Monica is a high priority area. However, again, many of you may know property owners in other parts of Los Angeles who might want to look into this program. It does also prioritize landlords who have 4 or fewer units, so smaller property owners. And then the property owner himself or herself has to have a household income that is 80% of the LA County area median income. So all of the details can be found on lacountyrentrelief.com. The application is not even available yet. It is going to open next week, next Wednesday, and be open through most of January. So if anybody's interested in this program, we certainly, again, encourage you to look into it. And with that, I will move it on to the next person.
I'll just because it's one of us. So Maurice and I are both going to talk about new ordinances that were recently adopted by the City Council related to the registration of vacant properties, and that includes rent control, non-rent controlled, and even commercial properties, and then the registration of all rental housing that is not rent controlled, whether vacant or not. So first, the vacant property registration, which Maurice is going to talk about, was actually just finally adopted last night, and the non-rent controlled rental property registration was adopted back in November.
All right, thanks, Romy. My name is Maurice Cochet. I'm with Code Enforcement. I'm one of the supervisors, and I oversee vacant property enforcement for Code Enforcement. So we do all the inspections and we enforce all of our municipal codes. And when it comes to the vacant properties, so this new ordinance, the vacant property registration, it's an amendment to our current vacant property ordinance, which was adopted in 2023. So this ordinance was enacted to enhance neighborhood preservation by requiring the registration and increased monitoring of vacant properties. The city has determined that current provisions of the vacant property ordinance need amendment to provide staff with greater enforcement flexibility and address emerging community problems. Vacant and abandoned properties are a significant problem, often leading to depreciated property values, reduced tax revenue, increased crime such as vandalism, squatting, arson, and the creation of unsafe and unhealthy environments. As of July 2025 this year, the city was aware of at least 167 vacant properties, with approximately half maintained in disrepair and non-compliance. So we decided a registration program is necessary because many owners are located outside of the area. And as of April 2025, over 100 owners had incorrect mailing addresses on file, making enforcement and notification difficult. When we set out to try to count all of the vacant properties that we had within the city, we sent out letters to that list. And we received over 100 of those letters came back to us, of former owners, owners that had moved, they never updated their property information. So this new ordinance amends the current vacant property ordinance by establishing a mandatory registration and monitoring program for vacant properties. So to define a vacant property is any property that is substantially vacant, and substantially vacant is any property that is less than 35% occupied. Unoccupied or abandoned for more than 90 days unless active construction with a valid permit is underway or an inspection has recently occurred. Okay, so the main requirement, which is mandatory, every owner of a vacant property must register their property located within the city and pay any required fees. That deadline for all property owners that own all property owners that own vacant properties is July 1st, 2026, or within 30 days after the property becomes vacant, whichever is later. And required information, the registration form must include a vacant property mitigation plan describing maintenance and security methods, contact phone numbers for the owner agent, description of the property's most recent use, future plans, and insurance information. Any new registrations form must be submitted within 30 days of a change of ownership or any materials changed to the registration information. Okay. Vacant property monitoring and tiers. Owners must pay quarterly vacant property monitoring fees established by city resolution to cover the cost of staff inspections and enforcement. The Code Enforcement Division issues an initial vacant property tier determination following an inspection. So after the registration, we will go out and conduct an inspection, and then we will assign a tier to that property. Owners may appeal a tier determination within 15 days of receiving the service. So every vacant property must be actively maintained and monitored and secured. So here are the vacant property tiers. So the ordinance establishes 4 tiers to classify vacant properties based on their compliance and risk level. This allows the city to prioritize enforcement efforts effectively. So tier 1, only de minimis or minor violations that do not endanger public health or safety. Tier 2, violations exist that are not de minimis or minor, but do not endanger community health and safety. Tier 3, an unresponsive owner and or conditions that endanger health and safety or evidence of trespassing. Then tier 4, conditions that immediately endanger the public health and safety of the community. Okay, vacant property framework. So they have to register their property. All vacant properties must be registered within the city by July 1st, 2026, or within 30 days of vacancy. Owners must adhere to new higher standards for property upkeep and security to prevent blight and crime. A 4-tier system ensures proactive monitoring and holds non-compliant owners accountable through escalating fees. And the effective date of this ordinance becomes effective 30 days from the adoption date, which was yesterday. It's December 9th. Okay, proactive approach. This proactive approach is designed to create tangible community benefits, increase accountability, ensures all property owners, including those out of state, are responsive and responsible for their properties, improve public safety, reduce opportunities for crime, and eliminate hazards associated with derelict buildings. Protected neighborhoods, it preserves property values and enhances the quality of life for all residents. And efficient enforcement allows city staff to focus limited resources on the properties that pose the greatest risk. All right, I'll pass on to Romy.
I'm going to talk a little bit about the non-rent controlled rent registry ordinance that was adopted. You all might be aware of the city's realignment plan that was sort of formally introduced at the end of October. Both of these ordinances were part of that plan as they go to both preserving housing and, as Maurice was talking about with the vacant properties ordinance, sort of revitalizing and protecting our communities. So the second piece of this is the non-rent controlled rental registry. I assume many of the landlords who are in the audience tonight are rent controlled landlords. So you're familiar with the fact that you have to register your properties, or you register your units, and after you register new tenancies with the rent control board. This ordinance is going to apply not to you, to landlords that only, or it will apply to any property that does not have rent controlled units on it, but it will serve much of the same purpose. The purpose of this ordinance is to essentially to assist the city in ensuring that the city's tenant protection laws and other state tenant protection laws are followed and enforced to the greatest extent possible. So this includes our own just cause ordinance that applies to tenants in other multifamily units that are not rent controlled units, and our other many tenant protection ordinances, including our discrimination ordinance, our tenant protection ordinance, as well as the State Tenant Protection Act and Penal Code 396, which we just talked about with price gouging. So as we'll see, the sort of information that we will be capturing on the rent registry is all information that will help the city, including those in our office and code enforcement and other agencies, have the information that they need to ensure that these laws are actually enforced. I'm going to sort of give an overview of what's in the ordinance rather than show text by text, but so there's several definitions. The sort of key definitions here are that the ordinance defines a property as any parcel or lot that contains at least one rental housing unit as defined by the ordinance, and then it in turns define a rental housing unit as a dwelling unit that is not subject to rent control, our local rent control law. And then it also defines a property as any person with a legal or equitable title to a rental unit, and it excludes a tenant, such as like a master tenant or a sublessee. In some parts of our tenant protection codes, we consider master tenants who have subleased their unit, in some cases, to be equivalent to landlords, at least as with respect to their subtenant. But for the purposes of this ordinance, this really applies to the duties of owners of property to register their properties. So the registration requirement is going to apply, as I said, to owners only. It will require that they register, again, their non-rent controlled properties annually after the ordinance takes effect and within 60 days of any change of ownership. So whereas the vacant property registration requirement is going to be an initial registration requirement either on July 1st or whenever the property becomes vacant after July 1st of next year, this registration requirement is going to be an annual requirement. However, the first annual registration and all the subsequent annual registrations that will come due after that has not been announced yet, and I'll talk a little bit more about how this is going to be implemented. But the first initial registration date is not even set yet. Once the ordinance gets implemented, the types of information that are going to be required on the registration statement, which is going to be a form statement produced by the city, will require the property address, the name and contact information for every owner of the property, as well as a manager or a person who is responsible for managing the property. We'll need to have information that will help the city determine whether the unit is subject to the Tenant Protection Act. So that might be information related to the ownership structure of the property, how many units are on the property, those sorts of things. We'll also need information to determine whether or not it might be subject to our local just cause eviction ordinance, which has certain exceptions. So we'll want to know whether it qualifies for any of those exceptions, and also whether the housing is subject to any affordable housing deed restriction, which many of our multifamily buildings built in the last 30 years or so are. We'll also require that the person who's completing the form be provided. In addition to information about the property, the form is going to require information about each rental unit at the property. So we'll need the rental unit address, so the specific identifier for that unit, the number of bedrooms and bathrooms, and whether the unit's tenant occupied. And then for every tenant occupied unit, we want to know how much that tenant's paying, when the tenancy began, whether they're using a voucher, amenities and utilities provided to the tenant or that might be paid for extra. And we want to know why, when the unit last became vacant and the reason for the vacancy. And this information, again, is going to be helpful to the city attorney's office and to others in understanding whether there might have been a violation of potentially the city's buyout agreements code. If the last vacancy was due to a buyout, but the buyout agreement wasn't filed with the city as required, that'll give us that information. We'll also know if people are being displaced because of rent increases or if they're being displaced entirely voluntarily. But we sort of need all of this information to have a full picture of, what the conditions people are living in and what laws might be violated. After a landlord submits or after an owner submits a property registration statement, the city will issue the property registration certificate, sort of certifying that they have complied with this requirement. That certificate will be good for that certification or that registration period, which will generally be a year, unless there's a change of ownership again, in which case they'll have to re-register within 60 days of the change of ownership. If the registration statement is incomplete, the city will notify the owner and give them an opportunity to fix it before the city sort of takes an enforcement action. So first, it'll be sort of an education first approach on getting that complete information. The ordinance requires that the landlord display the registration certificate once they get it in a conspicuous place in the building or provide a copy to the tenant. So the tenants are aware that the landlord has complied with this requirement. The ordinance also provides that if a landlord is under an obligation to register the unit and they haven't displayed their certificate, or either because they don't have one or they just haven't displayed it for any reason, they cannot demand or accept rent from a tenant of that building. And the tenant can also raise this as an affirmative defense to an eviction if the landlord hasn't complied with this notice requirement. As with the vacant property registration ordinance, this will require the payment, or likely require the payment of a registration fee. The city council will establish a fee likely sometime next year, but before the ordinance gets fully implemented. And again, those costs will be associated with, or the fee will be associated, or to recover the sort of costs that are associated with administering this chapter. Those fees will again be due at the time of filing, just like the registration statement, and landlords will be able to pass through 50% of the annual registration fee to the tenants on a pro rata basis. So like the rent control fees that are pass-throughable, the fees need to be equally passed through to tenants, divided. It's an annual fee, so it'll have to be divided by 12. So it's passed through in equal monthly installments in the rent. And it's only 50% of the fee that can be passed on in total to the tenants. Landlords of deed restricted units will not have this option because there's limits on what they can charge their tenants. And landlords cannot do this without first providing the registration certificate. The last section of the ordinance has to do with remedies and penalties for noncompliance. So if a landlord has not complied with their obligation to register a property subject to the ordinance, the city attorney's office could seek an injunction in court. We can also seek a civil penalty of $200 per unregistered unit per month. So if a landlord has fallen on their obligation to register like a multi-unit building for a year, these can be quite significant fines. The city attorney's office can also recover our attorney's fees, and we can also seek to be reimbursed for any investigative costs that we've incurred in investigating this. Additionally, code enforcement could issue administrative citations or fines, and a violation can also be treated as a criminal offense, as an infraction or a misdemeanor subject to separate fines and potential imprisonment. This is sort of a typical penalty structure for a lot of our ordinances, that they're both civil, administrative, and criminal remedies. So as I mentioned, the ordinance is not, the registration deadline has not sort of been initially announced yet. The ordinance was adopted and will take effect 30 days from the date that it was finally adopted, which was late last month. So it does take effect soon, but the ordinance provides that the initial registration date will be sort of announced in regulations adopted pursuant to the ordinance. So over the next year, several months, and I think through much of 2026, the city is going to be working on how to actually implement this ordinance, how to make this a seamless process for property owners, and we'll have more information forthcoming about when to expect that for initial registration statements will be due. We will be sure to include information on our website and other city websites when this is coming up. The idea is to gain compliance and to gain as much information as we can. It's not to penalize people or spring a registration deadline without giving people ample warning and opportunity to comply. So please just stay tuned for more information about how this will be implemented. Sometime, we'll certainly have more information about it in 2026.
Good evening. My name is Autumn Rendells, and I'm a deputy city attorney with the city attorney's office. I'm just going to go over some new state landlord-tenant laws that have come up this year. That majority of them will be effective January 1st. There are several that have been implemented or that will be implemented come January, but we chose 5 of them that we thought would be of interest to tenants and landlords. So we're going to first start off with Assembly Bill 246. This is, I think, a really exciting one for those who have or rely on Social Security payments for their rent. Under this Assembly bill, it protects tenants whose rent are late due to the delay in Social Security benefits. Now, something very important, this only applies to non-payment of rent. It doesn't apply to any other category. And if there won't be an eviction if your Social Security payment is late of no fault of your own and it's the government's fault, and once you receive the money eventually, hopefully, then you have to pay your rent full in 14 days after receiving the benefits, or work out a payment plan with your landlord. If you meet those 2 obligations, then eviction will not be able to go forward. We recommend that you keep bank statements and any other records to prove that it is not your fault. If this comes up for you, you will say an eviction or a lawful detainer is filed against you, and you do have to go to court on this. You will want to have as much evidence as possible to prove to the court that you are not obligated to pay rent during this time because of the Social Security delay in the benefits. For landlords, you cannot evict a tenant if they meet the AB 246 requirements, but that doesn't mean that you can't issue evictions or notices. You may still be able to do that. However, it will fail if delay is proven under what I had just described. You cannot retaliate or discriminate, as you should probably know, based upon this. And so I would just keep documentation very clear about what's happening, and communicate clearly with the tenants if this particular issue shows up. The next one, just briefly, is required appliances in California for rental units. This, again, Assembly Bill 628. There has been in the past some of the most obvious uninhabitable type of situations that have been around forever, such as you need to have heat, you need to have running water. There's a few other ones, but those are some of the key ones that would make a unit uninhabitable if the tenant doesn't have those things in their unit. Excuse me, I've been sick. This assembly bill now requires both a stove and a working refrigerator, or a working stove and a working refrigerator. This applies to all leases starting January 1st, 2026. So now stoves and refrigerators are part of that habitability requirement, and this is a big one. Manufacturer recall appliances are deemed unsafe and non-compliant. So if there are recalls to landlord provided appliances, you do need to get those fixed. And the leases must include the mandatory disclosure for tenant provided refrigerators. So for the habitability requirements, a stove, it must be maintained in good working order. You can't just get one off the street and hope that it works and hope that it turns on. It needs to be working, and it needs to safely generate heat for cooking. So you need to make sure that it's a good stove that you're giving a tenant. And the refrigerator must be maintained in a good working order, and it's able to keep food cool and safely store the food. What this new part of this statute doesn't really define is what good working order is yet. So we'll have to stay tuned to see what the courts decide on that. But I would, at the very least, ensure that it works, that it's safe, and it's doing what it's supposed to do. Things that are particular units that may not be covered by this is permanent supportive housing, single room occupancy units where you have shared kitchens. So if you rent out more than one room and they share a kitchen, this is not applicable to that. Residential hotels, units with communal kitchens, such as like assisted living type situations. And one thing is a tenant may decide to provide their own refrigerator, but they also need to maintain that. But one thing with that is there is an ability for a 30-day notice if, say, that tenant does not want to provide their own refrigerator, or their refrigerator breaks and they can't afford a new one. They can give the landlord a 30-day notice, and that landlord within 30 days needs to provide a good working refrigerator. The repair and replacement 30-day rule, owners must repair or replace non-working stoves within 30 days. And now there are going to be challenges. Maybe you can't get a handyman out there to fix it, or the repair people can't get out, and there's parts and pieces that will take a little bit longer. That's yet to be seen. I think you're going to just need to ensure that you're doing due diligence, and you maybe call around to a few different companies or repair companies. So there will be challenges, but as long as you, I think, do your due diligence, you probably will be okay and be able to get this done in 30 days. But again, that is something that we have yet to be seen on how the court will handle that. Again, we don't know exactly what good working order is and what not good working order is, such as if only one burner is working on a 4-burner stove. So I guess stay tuned on that. Unfortunately, they didn't define it just yet. Again, tenant supplied refrigerators, a tenant may provide their own refrigerator, or you as a tenant may decide you want to get your own. But the lease must include the required disclosure that the landlord is required to provide you a good refrigerator, but also you as a tenant may supply your own, but again, you must maintain it. You are then in charge of keeping it in good working order. But again, as a tenant, you can require the landlord to provide you a good working refrigerator with a 30-day notice. Moving on to AB 1414, this is tenants' right to opt out of bulk subscription services. In some instances, landlords, charge sort of bulk pricing for internet services. It's some bundle deals that sometimes they have. Well, residential tenancies beginning or being renewed after January 1st, tenants can opt out of this bulk pricing. And so this covers wired internet, cellular, and satellite services. And the landlords must allow the tenant to opt out of the subscription charges. The tenant does have the ability and right to choose their service provider. So this applies regardless of whether service is bundled with rent or offered separately. Landlords may not retaliate for this or attempt to evict because a tenant decides that they no longer want to pay for the particular subscription that the landlord has been requiring previously. And so prohibited retaliation includes, rent increases, decreases in services, trying to evict or move out. That would be considered tenant harassment. You don't want to do that. And protection applies if tenant is not in rent default. Remedies is the tenant may deduct the cost of the subscription from rent if the landlord continues to attempt to charge it after they have opted out. And the deduction, though, is only for the amount of the subscription, not for anything more than that. So the tenant should maintain documentation as well as landlords of exactly what's being charged, itemization, and that sort of thing. So if you do go to court, you have evidence on both sides of what you're charging and not charging and paying for and not paying for. Landlords, though, you may still offer the bulk pricing and bulk billing. The law only requires that you offer an opt-out. So you still can do it as long as you give the proper opt-out information, notice. SB 610, this is kind of a big one after the Palisades fire. It deals with disaster assistance to tenants and mobile home parks. I don't know how many mobile home parks here in Santa Monica. I know Palisades and a little bit outside Santa Monica were really affected by this. But if you live in a mobile park home and you prepaid for advanced rent, if you have been asked to leave for any emergency declared by the president or the governor, you don't owe rent during that time. And any prepaid rent needs to be refunded to you within 21 days. That's pretty much what that says. Landlord's duties after the disaster, this would apply to tenants in single-family homes, multifamily homes. A landlord must remove the debris and mitigate hazards. I know this has been kind of a topic after the Palisades fire of what duties are required by the landlords. And now it's pretty clear. The duty falls onto the landlord. And there is a presumption that if there is disaster debris at the unit or in the unit, then it is untenable for the particular tenants, whoever live there, to be there until it's cleared by health officials. And that is a big one. You can't require them to move in or continue to charge rent until an official actually clears and says it is okay for someone to live there and there isn't any hazard or safety concerns. The landlord's going to have to follow government cleaning protocols. A lot of times after these disasters, protocols come out or protocols exist for certain things. So you just need to ensure that you follow that if you're a landlord. And you must notify tenants and provide access to the environmental reports. I know in other situations, such as mold remediation, when there hasn't been a disaster, there's some fight over whether or not you need to provide those types of reports to tenants. In this particular case, you do have to provide those environmental reports to tenants. The tenancies remain active unless lawfully terminated. So just because the apartment building or the single family home no longer exists, it doesn't mean that the tenancy automatically is terminated. It needs to be terminated between the two parties. And so tenants do have the right to return to the unit at the same rent once it's safe and practicable. However, the government does not, or the state does not require that if something has burned down that the landlord replaces or rebuilds. That is a decision by the landlord. I think after that, though, if you're not going to rebuild, you're going to need to follow the relocation requirements. And local protections may offer additional rights. Santa Monica usually has some more protection, sometimes over even Los Angeles, the county, the city, or the state. So if a disaster happens again, God forbid, make sure that you're keeping up with what is required and what you're entitled to. Return of unpaid or prepaid rent, again, this also applies outside of the mobile park home situation, that you can be refunded money if you prepaid rent for the time that you're asked to evacuate your unit. And no rent is owed during a mandatory evacuation period. So just ensure that you as a landlord follow these requirements and meet the deadlines for payback, and ensure that you are not requiring payment of rent for someone to keep their tenancy if they are evacuated. And last one is AB 414, which is the security deposit. There's two major semi-major changes to the safety deposits. The first key change is electronic refunds and statements. Electronic refunds, I think before, had to be sent by either first class mail or in person, handed in person. Now they may be, the electronic refunds can occur if the tenant paid an electronic refund. Also, you can agree otherwise with your tenant if you want to do it a different way, but the default rule is if they paid for a safety deposit in electronic form, that's how you're going to return it. It's no longer just handing them a paper check. Itemized statements also may be emailed now. They don't have to, as long as you're in agreement with that, and you and your tenant are, then they can be emailed. They no longer need to be first class mail or provided in person. This is just helping to delay any sort of move out and improves documentation for disputes that may happen. The second one is key changes for multi-tenant refund rules. There's always get sticky when you have a multiple adults in a particular unit, paying different rents and who pays what. This is one check may be payable to all adults. So you just write one check, you put all of the adult tenants on that one check, and all you have to do is give it to one of the tenants. You don't have to ensure that everyone gets a separate checks. And again, this hopefully prevents disputes among the adult tenants, but also with the landlord. But it may be helpful for landlords to collect written agreements designating the refund recipient so that there isn't any sort of fallout from that. And now on to the next presentation by Jonathan.
Thank you. All right, so my name is Jonathan Irwin Frank. I am another Deputy City Attorney in the Consumer Division, and I am going to be talking about Chapter 6.22 So this is the technical legal name, the Residential Leasing Requirements Ordinance. Since that doesn't mean a whole lot, I like to refer to it as the medium-term rental ordinance. Now, some of you may be familiar with Chapter 6.20, which is our short-term rental ordinance, or sometimes called our vacation rental and home sharing ordinance. And that's the one that basically says that unless you have a home sharing permit, and for that you need a permit and a license, you have to meet all the requirements, and you're renting to someone who is staying in the unit with you at the same time as you are living in the unit. Unless you meet those very specific requirements, you cannot rent a residential rental unit for fewer than 30 days. And so this is kind of, I think of it as an add-on or the next level. This is Chapter 6.22. So there's kind of 4 or 5 major elements here for 6.22. So the tenant has to be a natural person. And this means that you cannot rent to an LLC or a business entity. So this often comes up in the types of situations where, for example, an employer is providing, a period of temporary housing for people who may be moving into the area and then, moving on to their permanent housing. But regardless of the situation, the tenant has to be an actual flesh and blood person. The initial term must be for at least 1 year. And I'm gonna go through these a little more quickly since we're gonna go into more detail in the coming slides. So the unit must be the tenant's primary residence, and the rentals must be unfurnished. So just a quick note, Andrew mentioned about that 5% increase for price gouging, but you really shouldn't be renting a furnished unit at all, because that is not going to be lawful under this ordinance. Unless you fall into one of those specific exemptions. And landlords have to give mandatory notice of these requirements. Okay, so the natural person requirement. Again, I already kind of covered this. Natural persons, not any of those different forms of business entities. There is an exemption for temporary tenant relocation under Chapter 4.36. There may be some familiarity with this. But under that scenario where, the pipe bursts and the tenant, the landlord is finding comparable housing so that their tenant has someplace to live while repairs are being done, that landlord could rent out that comparable housing unit, and they could rent it, listing themselves if they're, say, an LLC or a business entity, and then subleasing to the tenant for their relocation housing. Okay, the 1 year minimum initial lease term. The initial lease term, has to be for a period of 1 year. There's an exemption for, again, that permitted and licensed home sharing under Chapter 6.20. So another way to kind of think about this is that the ordinance is really intended to ensure that Santa Monica rental housing is for households, families, people of all kinds, but who are really living in Santa Monica as their primary home and as their permanent residence. So not for VRBO, not for Airbnb, not for vacation rentals, not for people coming to enjoy the beach for a few months. Okay, so I want to talk about this primary residence requirement. What does it mean that the unit has to be the tenant's primary residence? So that term is defined in the ordinance. It's the usual place of return for housing of the tenant. And crucially, it has to be documented by at least 2 of the following. So there's all those different options there. There are things that you can imagine that would kind of show that someone is really and truly living there as their main home. And they're not on a vacation, or they're, hold on one second. Not there temporarily. So we have the driver's license, the state identification card, voter registration, tax return, utility bill, and another specific documentation that relates to tuition. Okay, so you can only have one primary residence, and the landlord must collect documentation, both kinds, within 60 days after the start of the tenancy, and has to retain this documentation for the duration of the tenancy and provide it to the city on request. So you should always be able to prove relatively quickly and easily that this requirement is being met, and in fact, this person has the documentation to show that that is their only primary residence. Okay, so the unit must be unfurnished when delivered to the tenant. And that term is actually defined in the ordinance, and that's what's written out here. So without any furnishings and all of those other things, including appliances except for the stove and the refrigerator, we just talked about those, microwave, dishwasher, and washer and dryer. And there's an exception for sublessors and for one-for-one roommate replacements. And again, this is kind of in the spirit of the law, the idea being that it's for permanent residents who are going to be bringing in their own furnishings because that's their main home, not an Airbnb-er who's going to want to not have to deal with getting their own furniture. Okay, so the notice requirement. Landlord must provide all prospective tenants with a written notice. It has to be given with any application, with any lease. And if either the lease or application are processed electronically, that same form, that application form, that electronic document or PDF also has to have that notice provided electronically. And there is a specific form in the regulations, which means it's not that you make up your own form that provides this information, but there's a specific form that the city has created, which you can access online. Okay, so what are the remedies for violation of this ordinance? It is enforced by the city and by code enforcement. You could get an administrative fine of $1,000 per violation. It does carry criminal penalties. And there's also the possibility that there could be a lawsuit for unfair business practices, sometimes called unfair competition. That is a special type of lawsuit that Andrew mentioned earlier. It's also price gouging can be a city or a public entity can bring a lawsuit based on price gouging. That's also part of this same schema. And the remedies for that could include disgorgement of all the revenue from the unlawful rentals, meaning you would have to give up as a form of restitution every dollar earned from that Airbnb or that VRBO or that unlawful short-term rental, civil penalties of up to $2,500 per violation, and injunctive relief. There's also a defense to an eviction action and a defense to an action to collect rent. There are a limited number of exemptions where you would be allowed to do one of these medium-term rentals. These include ongoing tenancies that had commenced as of September 2020, basically before the ordinance was passed. Not likely to be an issue now. Lawful, licensed, and permitted home sharing, we talked about that. Temporary relocation under Chapter 4.36. And then there are specific requirements, specific scenarios where it's permitted to lease a single unit dwelling. So basically this is you are a homeowner or a condo owner of just that one condo or that one single family home. And let's say you have some kind of sabbatical where you're teaching abroad for 4 months. Then you're able to do this. I believe it's a maximum of twice in 1 year, and it can't be longer than 6 months or half of the entire year. There's also, you're not allowed to do this if you've previously evicted tenants, for example, under the Ellis Act, within a certain number of years. All right, and so with that, I will hand it off to Denise McGranahan to talk about some case highlights.
Thank you. Good evening, everybody, and last is best, hopefully. So I'm here to talk about some of the cases that we have filed, settled, won, and then we'll have questions after that. So this was a case that we filed in April of 2024 against a landlord of a triplex. And he had several tenants who complained to us. One of them was discriminated against her based on her disability. He discriminated against her. What he did was, after she asked to have her apartment tested for mold after there was a rainstorm, and she said, I'm immune compromised, and I need you to test my unit for mold, even though that should be something the landlord does under habitability rules. He didn't want to, and he said, I'm not going to test it, and this place is not suitable for tenants with special conditions, and it's not a wise choice for someone with respiratory issues, for those who require special care and attention. And if many of you have come to our Fair Housing Forum, and obviously it's pretty clear that those kinds of statements are intentional discrimination based on disability. So the interesting thing about that is he actually made those statements to the city attorney's office directly in response to us saying, why didn't you consider her reasonable accommodation, enter into an interactive process to come up with some solution? And his answer was this. So it was quite stunning. This same landlord, and this kind of gets to the registration issue. He failed to register with rent control his unit, but he had received information from rent control about how to do this and what his obligations were for years. We had that information. So the tenants who were renting from him, they didn't understand anything about rent control. I mean, maybe there's something sent by rent control every year, but they didn't really understand just cause. They didn't really understand that they couldn't have the rent just increased. But, he said, well, I'm renting to you, but, in 60 days, at any time, I'm going to give you a 60-day notice because I'm going to turn this into owner-occupied housing of some sort. And these tenants were standing, sitting there all nervous. They didn't know what was going to happen. So when one of the tenants had, her roommate moved out and she wanted a roommate replacement, and then she had asked for repairs, and the landlord basically said, no, you can't, have another roommate, and you have to requalify to live here, and we're going to sign a new lease, and I'm going to raise your rent like hundreds and hundreds of dollars. She complained to rent control. She complained to the city attorney's office. Other tenants complained to rent control as well. And letters went out from rent control to this landlord telling him, you can't do these things. And he still did them intentionally. He persisted. He was very stubborn. So we ended up, he did a lot of other things, as you can see here. One of the tenants had young children. He yelled at them. They ended up moving out. He wouldn't give proper notices to enter. He took away amenities. It's pretty much been a nightmare for people to live there. So we filed a lawsuit, and also the two tenants, each of them filed a lawsuit. So there were 3 lawsuits. And in May of 2025, we had a mediation, and we settled all 3 lawsuits for a total of $685,000. The city got a small portion of that because the goal of our litigation is to really help the tenants. When the tenants have their own counsel and their own cases, most of the bulk of the money goes to the tenants in that way, versus if we represent the city and we get the money, we would give it to the tenants typically if the tenant isn't represented. So most of the money goes to the tenants. That's the goal here. We got a stipulated judgment and injunction in the city's case, and this particular individual could no longer manage residential property in Santa Monica. He had to hire a third-party property manager who's been doing a really good job. So that was a really good thing. And he had to professionally test and remediate the mold, temporarily relocate the tenant during the remediation. That is an ongoing issue. Comply with all Santa Monica tenant protection laws and fair housing laws, attend a 3-hour city-approved landlord-tenant training, and pay a minimum of $10,000 per violation in the future. So it was a good result in that case. And one of the most egregious cases I've seen since I came to the city attorney's office, like about 2.5 years ago. This is another case, Jonathan's case, City versus Nahid Jahanbin. This was also pretty egregious. Jahanbin and her son, who acted as the manager, they bought this small property, and as soon as they bought it, they started trying to get these two people, this family with 2 young children out, in this campaign of harassment that spanned more than 2 years. The landlord first served like these incomprehensible notices saying you have this, they had this lease that was like, I think it was like a really, really long-term lease. Was that right, Jonathan? A super long-term lease? Like a 10-year lease. So the landlord challenged that, the new landlord said, well, this can't be valid. They had a good relationship with the prior owner, apparently. So they didn't want to honor that lease. So they first tried to, give them notices to get them out on that basis. They also turned off electricity. Then they did all kinds of terrible things. And then they brought 4 unlawful detainer cases. Well, first they tried to Ellis the property, and then they withdrew that. And then they tried to evict for, this is what they did. They called code enforcement in, they self-reported, and they said, the garage is unpermitted. It's been unpermitted and turned into a room. This was work that had been done years and years before. And they said to code enforcement, come inspect this garage, and they issued a notice of violation because it was unpermitted. But of course, only the landlord can pull a permit to do repairs, and the landlord is the responsible party. So the tenant couldn't do anything. So the series of notice, they get a notice that says you need to comply with this notice of violation within 3 days. In that we're going to come inspect. I'm hoping I'm getting this right, Jonathan. Yeah. Basically, there was no way for the tenants to comply, and they got representation from legal aid. And after the first case, when the tenant filed a dispositive motion, either, I don't know if it was a demur or some kind of motion, and the landlord dismissed. So the tenant was the prevailing party. And this happened 3 more times, okay? So this is the nightmare that these people live through. And they had their own attorney and filed their own case. There was a settlement reached in both cases in February of 25, and a stipulated judgment injunction against the defendants for the city. I think they ended up getting $450,000. I don't know how much the city ended up getting, some portion of that. The tenants did move out ultimately, but again, they can't manage properties in Santa Monica. They had to attend training. There's future violation enhancement for penalties, and they have to comply with the city's tenant protection laws. In both of these cases, we really hope these landlords don't ever buy any more rental property anywhere, because they were very bad landlords. Okay, this is a new case that Jonathan recently filed, and it's a source of income discrimination case involving a VASH voucher. This is a tenant, these 2 tenants, they're brothers. It's kind of sweet. They live together and they're veterans. They wanted to use their VASH voucher, and the landlord said, it's against my moral stance to sign up for government money. To the court we must go. Yeah. So, and there was also another issue about a lift for their mobility challenged, and they wanted to install a lift. So there's also a claim for disability discrimination. But the main issue here is source of income discrimination. But the good thing is, Jonathan was able to get a stipulated preliminary injunction. So the landlord's just accepting the lower amount of rent during the pendency of the lawsuit. So that really alleviates the pressure on the tenant. So the case is ongoing. And then we wanted to talk a little bit about 2 tenant relocation cases. One of them is Jonathan's case. It was a case the city filed against Goldie, who got ordered to pay temporary relocation in October of 2020. Then he didn't like that order, so he appealed it and lost. And eventually, the city filed a lawsuit to enforce the temporary relocation obligations. And Jonathan won a summary adjudication based on the fact that the hearing had already happened, and all of the things that happened in the hearing were binding on the court binding on, you weren't going to re-adjudicate all of those facts. So he won that, and now it's just a question of collecting the money for the tenant who has been sitting waiting for her relocation money since 2020. So it's kind of a victory, but maybe a Pyrrhic victory. I'm not sure. The other one is a pending case that I filed, essentially 2 tenants at a rent-controlled property who'd already undergone like so much construction. They were the only remaining tenants at the property. The landlord, and they had been temporarily relocated for a period of time. And then when they came back in December of 2023, their heaters weren't working. Like, they were off for a really long time, and they put them back on, and when they didn't work. So they got red tagged by the gas company. Our code enforcement had gone out to sort of to remove the order that had been on the property for temporary relocation, and then was issuing another order. But before they issued the order, they just said verbally to the landlord, these units are uninhabitable because there's no heat. There's no heat. It's the middle of the winter, and the temperature is below a certain degrees, 60 degrees or whatever the temperature is, and you need to provide temporary relocation, because one must understand that our relocation ordinance is self-executing. We don't need an order from code enforcement. If the temperature goes below 60 degrees and there's no working heater, the landlord's obligated to pay temporary relocation. So that was what happened in December, and then the landlord didn't pay, the tenants relocated. In January, the city ended up issuing these relocation orders retroactive, and the landlord didn't comply and didn't timely appeal. Then we filed a lawsuit in March of 2025. We really tried hard for a year to get them to comply, and they wouldn't. Anyway, so we have this lawsuit over pretty much $16,000 per tenant, which isn't a lot of money, but it's hard for tenants to get that money recover that money themselves. And so we're trying to help tenants when we can. That case is pending. Hopefully it'll get resolved soon. And that is pretty much all I have.